بسم الله الرحمن الرحيم. والصلاة والسلام على أشرف المرسلين سيدنا محمد وعلى آله وصحبه وسلم. بالأصالة عن نفسي وبالنيابة عن أكاديمية نسيج ونسيج المؤسسة الأم، يطيب لي في هذه الأمسية أن أرحب بكم جميعا، وأرحب بممثلي الهيئة الملكية لجبيل وينبع الشريك التعاوني معنا في هذه الورشة، سعادة الدكتور علي البار وكيل التعليم الإلكتروني بقطاع التعليم بالهيئة، وأيضا المهندس محمد منصور كلاوي مدير مصادر التعلم بقطاع التعليم والمسؤول عن المكتبة. ويقينا أتصور أن هذه النمط من التعاون مع مؤسسة ذات حجم يمتد تاريخها لما يقرب من النصف قرن هو إضافة لما سوف يقدم المعارف في هذه الندوة، وترتبط بالأساس في عصرنا الرقمي بما يعرف بحقوق التأليف وحقوق النشر وكيفية التعاطي معها في هذه الوقت. وأيضا معنا دكتورة سارة. دكتورة سارة هي أستاذ مساعد واختصاصية مكتبات في مجال حقوق التأليف بجامعة إلينوي، وهي تمتلك خبرة طويلة للغاية في القوانين الخاصة بالمكتبات والموضوعات المرتبطة بحقوق التأليف، وهي عضو في جمعية مكتبات الكليات والمكتبات البحثية ACRL، وعضو في كثير من اللجان التي تنظم تدفق حقوق التأليف والنشر ليس في الولايات المتحدة الأمريكية فحسب ولكن في العديد من الدول على مستوى العالم. أعطي الكلمة لسعادة الدكتور علي البر ليلقي كلمة الهيئة، فليتفضل.
السلام عليكم ورحمة الله وبركاته، حياكم الله جميعا. شكرا دكتور عبد الله على المقدمة. حقيقة الكلمة راح تكون باللغة الإنجليزية لتواجد الدكتورة سارة معنا. Good evening. Thanks to each and every one of you for being here with us today. We are very pleased to be able to welcome all of you as well as our partner Naseej Academy, and our special thanks go to Dr. Abdullah Mutwalli, the General Supervision at Naseej Academy, and also we would like to thank Professor Dr. Sarah Benson, who is joining us from Illinois University. We are proud to be able to host this event today after breaking all the limits of geographical locations and be able to conduct it virtually with all of you. Before we get this started, I would like to express my sincere appreciation to all of you who generously helped us make this event come together to become a success. Dr. Fahad Al-Qurashi, the CEO of Royal Commission in Yanbu, and Dr. Maher Al-Ghanib, the Director Manager of Royal Commission in Yanbu, the Director Manager of Royal Commission, Yanbu Colleges and Institute. We could not have done it without their support. In fact, our e-learning agency at RCYCI, in the agency, we concern actually about the integrity of learning resources to serve researchers, faculty members, and all people who are interested in writing and conducting research in our industrial city. In this webinar, participants will gain knowledge about information that focuses on how copyright and intellectual property law impact services, impact licensing and access to different types of resources. And the main focus will be to show how plagiarism and copyright rules impact beneficiaries and librarians in their daily work. I don't want to take too much of your time. I need to leave sometimes for Dr. Sarah and to share with us her experience and start her lecture today. Hopefully we will be very informative and have full of learning, inshallah. Again, thank you very much, and I wish you a wonderful webinar. Thanks to all.
Thank you, Dr. Ali, and I'm so glad that you give this speech, and it's enlightening a lot of points in the agenda for Sarah. أشكرك جزيلا Dr. Ali, and بأكد على جانبين. I want to confirm about that. All the questions we will receive it at the end of the workshop or the webinar, and also it will be written through the question and answer books or the chat. And Dr. Sarah will answer it, and I will help in this one. Even if someone needs to give a question in Arabic, I will translate it. So now I will leave the stage for you, Sarah. So it's yours, and we give this preparation to give the sense of what we will do this one. Please go ahead.
Thank you very much. I trust everyone can hear me okay. I would like to thank Naseej Academy for inviting me to speak with you all today. Today we're going to talk about the impact of copyright and intellectual property on library services in the virtual age. And of course, I welcome any questions that you have. You can post them in the chat and we will answer them at the end. So a little bit of background about myself. I am a lawyer. I operate as a copyright librarian at the University of Illinois, and I also teach at the iSchool, the Information Science School at the University of Illinois. And as a copyright librarian, I provide access to legal information but not legal advice. So nothing in this webinar should be taken as legal advice, but rather access to legal information and resources that can help you. So what is the role and the mission of the library space? This is the University of Illinois library mission statement, and it states that the library advances the university's goals by ensuring unfettered access to information and by providing a network of expertise that ensures value, quality, and authenticity of information resources. And I highlighted the word access here because, as most of you know, this is the primary concern of libraries, especially in an age where there's a lot of misinformation floating around, as we like to call it, fake news. We try to provide information resources that are, quote, authentic, right? Authentic means that they are valid, that they are we're ensuring the quality. We're not collecting fake news, right? And that we provide access. And so our primary goal is to help our patrons access the vast array of information that we store and preserve. And the reason I bring this up at the beginning of this talk is because the rest of this talk is going to talk about how we allow our patrons to access that information using copyright law and intellectual property law. We have special, what I like to call them, superpowers as librarians, as libraries, that allow our patrons to use our services that maybe if you were an individual with a library in their home, they would not be able to use such broad access measures. So that's part of why I started this talk by discussing the mission of the library. The other thing I would like to use to center this talk is to point out who has access. So at the University of Illinois, for instance, we provide access to faculty, staff, students, and community users in the state. Now, why do I bring this up? Because as a library, we are limiting our reach to our patrons, right? We do often at our library, and many libraries, offer interlibrary loan services, digitization services, and those may have broader reach to a general public. But when we license information, we pay for contracts to provide journal articles online, for instance, that's where we're limiting our service to our patrons. And that's when you need to know, who are your patrons, right? Are you serving a specific faculty, staff, and students? If you are, those are your patrons. And you're going to be limited often by those licensing contracts to providing services to those individuals. And so that's the other reason I brought up access, is in terms of who we serve, and knowing who you serve is so very important, because your library licensing often is limiting access to your patrons. So library spending, we all have library budgets, and hopefully they're large. At University of Illinois, we're one of the largest university libraries in the world. Our collection is right behind the Library of Congress and Harvard. So we really have a large budget However, our budget does come with restrictions, right? So the library is acting as an agent, and we are entering into legally binding contracts with vendors on behalf of our patrons and library users. So we do have a lot of limitations within our contracts, our licenses, that limit the access. Even though we're paying for these services, our databases, our journals, etc., we do have to understand that normally access is limited to our patrons. And so our patrons, when they get access to our digital library, our e-books, our e-journals, they're not meant to then take that e-journal and send it to all of their friends or put it on the internet. That would be violating our licensing agreements. And so we do have to pay close attention to who we are serving and how we are serving them. So I want to step back a moment and talk about the different types of intellectual property that impact library services. So copyright is just one branch of intellectual property. When we talk about intellectual property, we're talking about three different topics: copyright, trademark, and patent. And all of these things could impact library services and university services. So copyright is most relevant to librarianship because it covers all the creative things that we collect, such as books, videos, music, creative arts, and even sculptures and things like that. Patent, on the other hand, involves the protection of inventions, and normally we don't collect inventions in libraries. Patent is obviously applicable to university services more generally, because we do, at least at University of Illinois, have researchers who are patenting products, and the university has an interest in that. Trademark is more about businesses protecting their brands. Since a library is not a business, we're usually not dealing with trademark either. But of course, we might have Elsevier, for instance, products, and their trademark is the tree that you're familiar with. And so we might be interacting with trademarked things, but normally the library is not in the business of using trademarked works in terms of trademarking their own things. So most of this talk is going to be about, of course, then copyright. So what is copyright? Copyright is a protection that extends to creative works, like I said, music, writing, maps, most things that we have, books, journal articles, right? Things that we collect in libraries, and it's automatic. There's a lot of people don't understand that you don't have to do anything special in order to get a copyright. So once a minimally creative work is fixed or written down or recorded in a tangible medium, which is, write it down on a piece of paper, record it on a recording machine, then, or type it into a computer, copyright protects that work automatically. So you don't need to do anything special. You don't need to register the work or put a copyright symbol on the work, although those things can be helpful or even necessary in order to sue someone, at least in the United States. But still you have the copyright automatically. And that's important to note, because most things that we have and that we collect in libraries are owned, are copywritten, and they're owned by sometimes the author, if it's something that's unpublished. If it's a published work, usually it's the publisher who owns the copyright. But in any event, rarely are the things that we collect copyright is owned by the library. That's rare. Sometimes in archives, we will own the work because the author transfers the copyright to the archive. But generally speaking, what we're dealing with, what we're handling in libraries is work that we don't own the copyright for. We have possession of maybe the physical object or even the digital object, but we don't own the copyright. And so that's important to bear in mind. So this is just kind of a visualization showing you originality is the minimal creativity that is required in order to have copyright protection. For instance, copyright does not extend to facts. Facts are not original or creative, they just are. And so we cannot copyright facts like dates and numbers and things like that. And then fixation is just writing it down or recording it, and then you automatically have a copyright. So what are the rights that stem or flow from copyright? We have what's called the bundle of rights, and all of these rights automatically flow to the creator or whoever owns the copyright. And we call them the exclusive rights. So what are they? The right to reproduce or make copies of the work, the right to distribute or sell the work, or put it out in the world, make copies and put it on the internet, the right to create derivative works. So if you write a book, you want to write another volume of the book, that would be a derivative work. The right to display the work, as in putting it in a museum, and the right to publicly perform the work. So to do a reading of the book aloud, to perform a play, an opera, those kinds of things. Those are all of the rights that automatically accrue to the creator of the work. And if you think about it, those are the things that we do in libraries, right? We don't own the copyright, but do we reproduce or make copies of works? Of course we do, right? Especially for interlibrary loan, or our patron might come in and copy something in a copy machine. We of course distribute the work because we are allowing patrons to borrow the work. And so all of these things interplay with copyright. So there are some norms that apply to many different countries via their recognition and signatory to the Berne Convention Treaty. So Berne Convention requires that countries have no copyright formalities. The formalities are when you have to have a copyright notice on the work before the copyright will be acknowledged, or if you had to register the work with a specific office. So if you're a Berne Convention country, which most countries in the world are, including the United States, you cannot have any copyright formalities in your copyright law. Berne Convention also permits and requires protection for moral rights. In the United States, we have very limited moral rights, and it's debated whether that is appropriate under the Berne Convention, but there must be some protection for moral rights, like the right of attribution, the right to be forgotten, those kinds of rights. We have some exceptions to copyright, but the Berne Convention limits them and says that they have to meet a specific 3-part test. And again, that is debatable whether the fair use exception in the United States actually satisfies this limit, but generally speaking, the Berne Convention tells countries, okay, you have to, in order to comply with Berne, have your own copyright laws. So each country has their own copyright laws, but they should have these things in common. The minimum copyright length or term has to be life of the author plus 50 years. And again, that can vary. It can be longer, just not shorter if you're a Berne Convention country. And finally, you have to have national treatment. You have to respect the rights of other nations. So if you are a member of Berne, which the United States is, then we need to treat international copyright like we would treat our own citizens for copyright, and respect their copyright laws. So this is very important, and this is why countries want to be a member of Berne, so that their country's copyright laws are recognized by other countries. So just to show you some of the Berne Convention countries, here is a list of the countries as well as the date at which the country joined the Berne Convention, which for the United States, we had to amend our copyright law after we joined Berne because it changed our laws. as you see, Lebanon joined the Berne Convention before the United States. The United States was actually a pretty late adopter of the Berne Convention because we did have formalities in our law and we didn't want to get rid of them. And so we just didn't, we were late adopters. But many of the countries, hopefully folks who are on this call, your country is represented here, which means that there are a lot of commonalities between, for instance, United States copyright law, which most of my talk is centered around, and your country's copyright law, because Berne makes us have some things in common, right? The length of the term, the fact that we have to respect other countries' copyright law, we can't have any formalities, all of these things. So this tells me, for instance, that Kuwait, as of 2014, doesn't have any formalities in its copyright law. It also tells me that Kuwait has a minimum of the author's life plus 50 years for protection for authors. So these things, it's very helpful to know whether your country is a member of the Berne Convention. And like I said, almost every country in the world is. And that just gives us some commonality when we're understanding how copyright works in different countries. So in the United States, for works produced today, like I said, protection is automatic once a minimally creative work is fixed, and that's part of the Berne Convention also. And the bundle of copyrights in the United States lasts for quite a long time. So if I create a work today, it's going to be copyrighted automatically to me for my entire life plus 70 years after I die. So that's a very long time. And like I said, the minimum under Berne would be 50, but in the United States, it's 70. Let's look at some of the other countries. So in the United States, it's a little longer, it seems, than many other countries where they might be following the minimum that's required under the Berne Convention of 50 years. That doesn't make a huge difference right now, but it can make a difference in the future, right? Because when those 50 years after death are over, then the work enters the public domain and anyone can use it, right? The public domain means copyright has expired and anyone can use the work for whatever purpose. And you could digitize the work and put it on the internet and share it with no copyright restrictions. And so those 20 years can make a big difference, right? At some point, a lot of folks are a little upset that the United States has such a long copyright law because 20 years is a long time. And so works from your countries, some of these countries displayed here, such as Egypt, they might come into the public domain a lot sooner than works in the United States. So what does copyright law protect and what doesn't it protect? I talked a little bit about this earlier, but copyright law protects things such as software because we consider it a literary language. Those ones and zeros become a language. Writing, books and journals, artistic works and sculptures, architectural plans and maps, musical scores and recordings. So if some of you collect musical works, that is also protected. What it doesn't protect are facts, as I mentioned earlier, or ideas. You can't just have an idea and say it's protected. You have to write it down or record it in some fashion. Short phrases and titles such as "just do it" for Nike, that wouldn't be protected under copyright law, but you might be able to protect it as a brand, which Nike has done, of course. And then method of operations or inventions might be a patent, but not a copyright. So we're going to focus most of this talk about copyright. And as I mentioned earlier, those bundle of rights, the work is allowed, the author is allowed to reproduce, distribute, create derivatives of the work. And a good thing to note is that derivatives include translations. A lot of folks don't realize that, and they might think that if you translate a work, you don't need permission from the author or publisher to do so, but actually creating a derivative is considered, creating a translation, sorry, is considered a derivative of the work and actually is not permissible unless you have permission or you've paid a license. So that's one thing to bear in mind. If you have any researchers who would want to do a translation of a popular work and it's still under copyright, they would need permission to do so. The right to perform and display the work. All right, so let's take a moment to discuss the differences between copyright and plagiarism. This often becomes an issue in academic institutions, and students are often confused about the difference between plagiarism and copyright. So copyright, of course, is a legal issue, and it requires the person trying to use the work to get permission to use it or to redistribute or reproduce the item. So plagiarism varies because it's an academic standard. It's not a legal standard. And plagiarism requires proper attribution to cite or quote an item. Now, the reason I think that people get confused is because copyright and plagiarism often look very much the same, right? If you copy an entire work and turn it in as to your professor and say that you wrote it, you have probably committed both a copyright infringement and a plagiarism, right? Because you are saying you didn't attribute the item, and you also made an infringement. You didn't have permission to use it. However, sometimes they don't overlap, right? Because at least in the United States, you can quote things all over the place without copyright permission because a really brief quote is considered a fair use, or in many countries, an exception, a copyright exception. However, if you do not properly attribute or use quotation marks around a quotation, that would be plagiarism and not necessarily a copyright violation, right? So the two often overlap, but they don't always overlap. And of course, plagiarism is something that professors can use to give a student a negative grade or take points off or even fail them, or even in the worst case scenario, they could get kicked out of the university. But copyright is not going to incur the same kinds of things, right? Copyright can, when someone violates copyright, usually the issue is that they will get sued, right? If a student is repeatedly violating copyright by downloading things from the university server, like journals, and just copying, usually what happens is that the journal managers on the other, Elsevier or whoever's providing the journal will see that use on their server, and they'll contact the library and say to the library, someone is using our source in large amounts and downloading large amounts, and we think that it's violating the terms of service here. And at that point, they might even shut down the library's access to that source. So it's what happens at our library. If we get told that, we will try to identify who it is, if we can figure it out, which patron is doing that, and we will warn them that they need to stop doing that, or we will shut off their particular use of library resources so that the library doesn't get turned off from the vendor. So that's why it's important to understand, copyright can be a legal issue. In that case, it even becomes a contractual issue, right? Because they're violating licensing with the vendor. So you can have different actions that are taken in the law, or even actions that are taken under the contract, right, to stop access. But plagiarism is an academic standard that means that the student might get a negative grade or something like that. It doesn't really impact the library, right? But copyright, if the student is violating copyright, it might. So tips to avoid plagiarism: every time you paraphrase, you're supposed to cite a work, right? Every time you quote from a work, you need to use quotation marks and cite the work. Those are things that students learn in the classroom. Sometimes we as librarians help them to understand plagiarism as well, right? We're often asked to talk and guest lecture to English classes about plagiarism. But that's a very different topic from copyright, even though they sometimes overlap. All right, so where are the places where copyright and library services really are important to know? The first is first sale, and next is copyright exceptions, and finally licensing. And I've talked a little bit about licensing already, but we'll come back to it. So this is the order in which I'm going to proceed through the rest of this talk. So first sale, what is it? First sale is what allows anyone to lend or sell physical books, and the publisher is making money from the first sale. So the first sale is when I go, let's say, to a bookstore and I purchase a book. Let's say I pay $30 to the book. The publisher has made royalties from that sale. Once the publisher has made royalties from that sale and I have that physical book, it is mine to do with what I wish, right? Except for copying it. I can't just copy it and put it on the internet, but the physical book itself, I can lend to my friends. I can sell it on eBay, on the internet, right? That's the principle of the first sale, that the publisher already made their money, they're done, and now I can do with the physical book what I would like. So in the United States, most library lending operates under the right of first sale because patrons come to the library and they check out a book, and it's a physical book, and the library is paid for the physical book, and then we can lend it as much as we can, right? Of course, we have to try to preserve the book and make sure that it doesn't get destroyed, but we don't charge for lending. We don't usually, at least at our library, we might have late fees and things like that. Or if they damage the book, we might have a charge, but we lend it to our patrons for free because the publisher's interest has ended, right? So we don't have to pay the publisher anymore. We can lend, let's say, a copy of Harry Potter 500 times in the physical book, right? We don't have to keep paying every time we lend it. The difference is that some of this is also referred to as exhaustion, copyright exhaustion. And I looked into whether your country, some of these countries that hopefully are represented on this call, have the right of first sale or the right of copyright exhaustion in the Middle East. And I found that Egypt actually does have it in Article 147, and in a couple other locations, I did not find a right of first sale. So if your country does not have a right of first sale or exhaustion, then all library lending would have to be permitted explicitly within the Copyright Act. And some countries, because of that, because of no right of first sale, charge a fee for library lending because they have to still pay the authors or publishers for every time they lend the book. In the United States, we don't. We do not pay to lend. We just pay to buy the book, and that's the end of the right of the publisher. So I'll give you an example. There's no right in Saudi Arabia of copyright exhaustion, but there is an exception for using the work for educational purposes within the limits of the intended objective. It's a little unclear, though, what using the work includes. And the question is, does it allow copying? When I looked at this section, it seemed very similar to the United States exception to the use of any copyrighted work under Section 110(1) of our Copyright Act for the performance or display of work during face-to-face teaching. And when we describe face-to-face teaching, we're talking about when I'm physically in a classroom, which has definitely become limited in COVID-19. But this is a very broad exception for the performance or display, but doesn't allow copying of the work. That might be very similar, right? You might be able to show the work, display the work, but not necessarily make a copy of it. In the United States, when we make actual copies for reserves, e-reserves, or library lending for teaching, we're relying on fair use. So some of the copyright exceptions that the United States has and follows are the face-to-face teaching exception, which I just described. the preservation and interlibrary loan lending, which varies from country to country, and access to works for the visually impaired under Marrakesh Treaty. So that was already discussed. Okay, so under the teaching exception, the question is, at least in the United States, could you, under face-to-face teaching, play an entire copy of a film you borrowed from the library, show copyrighted images in a PowerPoint display, or distribute 5 chapters out of a copyrighted book to your class that you photocopied? And the answer is, at least in the United States, you could do 2 out of 3 of these things, right? You can play an entire copy of a film you borrowed from the library because you don't need to pay for public performance rights because it's under the face-to-face teaching exception. You're allowed to display or perform any entire work in face-to-face teaching. It's gotten a lot more complicated for us in the US under COVID-19 because most of our things are done online now, and this exception is we're not really allowed to rely on it. I'm assuming in your countries you've also probably faced this problem, and we've had to pay for a lot more licensing for performances through streaming services. We are allowed to show copyrighted images in a PowerPoint display and face-to-face. We do so online as well, but we are usually relying on fair use, which is a general, broad kind of umbrella exception. And can you distribute 5 chapters or make a copy of 5 chapters out of a copyrighted book to your class? No, not under the face-to-face teaching exception because it doesn't allow for copying. It only allows for performance or display. But still maybe under a different exception. So this is where you need to really read your copyright law and know the different exceptions, right? It might not apply under one exception, but there might be another broader exception that you could use. In the United States, we would apply fair use and say, maybe we could do that. So going back to our Saudi Arabian exception for teaching, again, it said using the work by way of clarification for educational purposes within the limits justified by the intended objective. Does this work include copying the work? Does using the work, include copying the work? Maybe, right? If so, it's maybe broader than the United States section, right? You would have to look at what guidance, if any, in the courts or in the legislative history is given for the word using. What do they mean by that? Because in the United States, we're talking about performance or display. And I don't know what using means, but if it does allow for copying and distributing the work, it might even be broader, and that's great if it is. It's key to knowing your own country's distinct laws. So library exceptions to copyright. This is what I kind of call the librarian superpowers, right? Because normally, if you're not operating in a library, you cannot make copies of copyrighted work and distribute them. But in the United States, under Section 108 of the Copyright Act, librarians can make limited copies for interlibrary loan as long as they're not replacing the need for subscriptions. And we're not supposed to give entire works or the entire book a copy of it if it's commercially available for purchase. So it's kind of rare that we can make copies of entire books, but we often make copies of a particular journal article for another library, or a chapter of a book, or a couple pages of a book. And we're allowed to make library copies for preservation. For unpublished works, it's automatic. For published works, we have to show that they're deteriorating or lost, right? Because otherwise we'd just have backup copies of books, and we wouldn't, if a patron lost a book, we wouldn't have to purchase the book, right? But interlibrary loan and preservation are really our superpowers in the United States. I would assume that many of your laws have these types of exceptions as well. So let's look at Saudi Arabia. In Saudi Arabia, making a copy or 2 for public libraries or non-commercial documentation centers on the following conditions are okay. Shall not be commercial or for profit. Copying shall be restricted to the requirements of the activities. Shall not impair the material benefit of the work. And the work is out of print or is lost or damaged. So if all of the conditions must be met, this would be pretty limited. But remember, we still could lend physical books for educational purposes. And I think most of these requirements are pretty standard. So in the US, we also can't lend for if it's commercial or for profit, or we can't impair the material benefit of the work. It's restricted to the requirement of the activity. For us, it has to be for research or personal study. We don't always require that the work be out of print or lost or damaged. So for our Section 108 lending, that would be a requirement if we are trying to lend the entire book. If we're trying to make a photocopy of an entire book and send it to another library, it would have to be, you know, out of print or lost or damaged. But for us, if you're making a copy of a chapter or a couple pages or just one journal article, that would be perfectly okay. And it may be that that's true in Saudi Arabia as well. Since I don't read Arabic, I may not have completely understood. So if you do know, please let me know for sure. But if it's read similarly to the way we do in the United States, this is very similar, and it looks like it would work. Of course, we do still lend physical books. We can lend them through consortia under the right of first sale. So if somebody wants not one page from a book, but to borrow the entire book, what we would do is send the book, and we would ask that we get it back within a certain period of time. And we could do that under the right of first sale. Remember, we can lend the physical book, just not making copies of it. All right, so good news regarding digital locks. So what are digital locks? So when you try to watch, for instance, a DVD online, it might have a digital encryption that stops you from making a copy of the work, right? Because it's protected in copyright, and they don't, the person who made the DVD, they don't want you to make copies of the DVD. In the United States, it is generally illegal to break digital locks, right? Because we're not supposed to make random copies of DVDs and things like that. And that is in addition to the copyright violation for making the copy. So you're going to be liable potentially for infringing copyright as well as breaking the digital lock. In the United States, there are limited exceptions for libraries and teaching purposes, such as using short video clips for teaching. So if you're going to teach a video film class and you need to use short excerpts, you can break the digital lock to make copies of those short excerpts without paying for the use. Now, so some of your countries, it seems, do have these availability to break digital locks, and some of them don't. So that it's helpful to just know that in these countries, for instance, Egypt, you have an exception for breaking digital locks. It does say that there are no exceptions for libraries, so that's not quite as helpful as our law, but at least you can do some amount of it, right? So Joanne wishes to show, here's a hypothetical, a short movie clip in her online class. Can she break the technical locks on the DVD to make a copy for this purpose? In the United States, she could, as long as the excerpts are short. And unfortunately, we don't define the word short. So we have to use our good judgment, and it really is based on fair use. And fair use generally says, is it for educational purpose? Are you not taking too much? Are you not impacting the market value? So we're generally looking at if it's a fair use. What about, we say yes, as long as the copying qualifies as using the work, right? Remember I said that exception for teaching in Saudi Arabia. So that is a yes as long as the copying qualifies as using the work. So that's interesting. Some countries just say no. What about copies for disabled patrons? Can you make copies for visually impaired and otherwise print disabled patrons without violating copyright? So if you have someone who says, I need this book in a different version because my screen reader cannot read it in the current version, this would be where the Marrakesh Treaty comes into play. So the United States signed the treaty on October 2nd, 2013, but we did not have the full force of law until May 8th, 2019, because we had to go and modify our regular laws to catch up with that. So interestingly, this says where some countries have put the law into force. And this is great, right? Because that means that if your country has signed the treaty, then you would be able to also lend these works. And this treaty also says that you can lend internationally. So if we have a patron reach out to us internationally who also can't get a hold of a screen reader version through their local library, there are provisions that allow us to lend even internationally under the Marrakesh Treaty. Okay, so we're gonna switch gears a little bit. Wait, let's do this first. So hypothetical. What if a patron wishes to read a book from your library that is still under copyright protection and they need you to provide an electronic copy of the book for their screen reader as they are visually impaired? Can you make a copy of the book and lend it for that purpose? So remember, you're not just giving them the physical book, which would be a first sale, right? You're making a copy of it. In the United States, we can. We do have to provide the copy to an eligible person, so a person who legitimately needs it for that purpose, and include, of course, a copyright notice on the copy we provide. In countries that have signed the Marrakesh Treaty, the answer is the same. And even internationally across borders, we're allowed to with other Marrakesh Treaty countries, which is great. Okay, so what is library licensing? Let's switch gears and talk about library licensing. We've talked about all the copyright exceptions, and now we're moving into licensing, which is kind of the final portion of the talk. Licensing is just a fancy way of saying contract, and it is something that libraries enter into on behalf of their library patrons and users, right? Why does it matter? Why do we need to read and understand our library licensing? Well, library licensing matters because violating the licensing can cause a patron to lose access to services, cause a vendor to remove services, or even result in a lawsuit for breach of contract, right? Because the library entered into a contract on behalf of its patrons. Unfortunately, often the patrons do not understand this, right? Sometimes they think that the databases that we have access to and the journal articles that we have access to are free or are just provided because they go to this school, or they could even access them after they leave, and they get very surprised when they leave the university and they no longer have that access. But the reality is that the library is paying for these subscription fees so that we have access to specific services. And sometimes, and you know this, librarians, that we decide a particular vendor's journals are not being accessed enough, and it might be time to stop paying for a specific journal. And then a patron might say, wait, where did this journal go? I thought we subscribed to it. And all of the journal is gone because we no longer have access to it. And so it's really important for patrons to kind of understand that the library is paying for these licensing and that we're doing it on their behalf. Because if they violate the licenses, that can have negative implications on themselves as patrons, because they might lose access to the services, and the library, right? Because if the vendor gets really upset that patrons are violating it all the time, they might remove the service or refuse to enter into contracts again with the library. So Some tips to avoid copyright violations. One thing that I always recommend is to post copyright law reminders near public-facing copy machines, and to include copyright notice on all copies of lending material. Of course, not in physical books because they already have it inside, but if it's a journal article that you're lending through interlibrary loan, our laws in the United States require us to provide a copyright notice. It's also a really good idea to remind faculty members who are posting things on, say, their course websites and things that are behind a paywall to put a copyright notice on it so that their students are aware that this is probably copyrighted material that the library doesn't own the copyright for, and that they shouldn't just download it and send it off to whomever. I think it's also a really good idea to learn what your individual copyright laws are. Unfortunately, there's no one international source of copyright law. The Berne Convention is as close as we can get, right? Because it provides guidelines for all the countries that they must have in their laws if they are a Berne Convention country. But then each country has its own laws. So most of my talk has been focused on the United States because that's the law that I'm the most familiar with. Each country has its own copyright laws, and you should try to familiarize yourself with them, especially the parts about library lending, whether you're in the Marrakesh Treaty, exceptions for teaching and learning, exceptions for the libraries, and whether you have for sale or exhaustion. So what should you do if a patron is violating copyright law? So the question is, what would you do if you saw a library patron blatantly using a copy machine in the library to copy an entire book illegally? This seems like it's probably occurs almost every day, right? You see, you can't copy an entire book, right, without permission from the publisher. It's very rare, right, that we could do so. Even as librarians, we could do so for preservation purposes, sometimes for library lending if it's out of print or something like that. But generally speaking, we're not supposed to do that, and neither should our patrons. Well, at least in the United States, you shouldn't do anything. As long as you have a sign reminding the patron that the works in the library are covered by copyright law, the library employee is not responsible for illegal actions taken by the patron, especially if this copy machine is for patron use only. So in the United States, it says that if we have unsupervised copying equipment, unsupervised being the key, and we have a sign reminding them about copyright law, it's up to the patron to follow the law. And the reason it's problematic when a library employee gets involved is because our law requires it to be unsupervised equipment. And once the library employee starts taking actions, then they're creating a link between the library and the copying equipment, and that becomes problematic. But what if the librarian made the copy? Well, that would be different, right? This varies depending on the law. In the United States, the copies might be legal under Section 108, or they might be legal if it's a copy for a disabled patron, or it might be fair use, right? There are variable things going on here. It depends, but generally speaking, right, if it's not a fair use, if it's not an exception, if they're just making copies, then it's problematic as well, right? So it depends. You have to look at whether there's an exception that applies here, because of course librarians have what I spoke to earlier about superpowers and special exceptions that patrons don't have. So the librarian might have been able to make the copy, but the patron might not. Either way, in the United States, we don't supervise our copying equipment because that's what the law tells us. The law says you just have the copy machine and it's up to the patron. Just make sure you have a nice big sign there reminding them about the copyright policy. All right, let's talk about some other examples that implicate library licensing. So what if a patron wishes to download a really large grouping of documents from ProQuest in order to run text mining software for research purposes? ProQuest is a database and they have a lot of journal articles in them. I use them as an example, but it could be any database with journal articles. And the patron really wants to download lots of journal articles all at once and keep them in a file. What should you do? Well, I think immediately this should raise a flag for you that this is a licensing issue. And you probably need to take a look at your library licensing and look at any limitations on large document downloads. For instance, your library licensing might prevent any individual user from downloading more than 50 documents at a time. Or in some of our contracts, it says they're not allowed to keep records of any journals for more than 90 days. So it's really important that you look at the licensing, and you would need to have a conversation with the patron about what they're trying to do. Maybe their research is completely valid, but you'd need to have them hold off on it until you can talk to the vendor. I've had a lot of success in talking to vendors about specific research things that our researchers need to do, and the vendors have been often able to either write it into an addendum to the contract or allow us an exception, or we've even have some contracts and vendor licensing year to year that we know have ongoing text mining going on from researchers, and we have allowed, the vendor has allowed an exception for text mining. It says, you know, you can't download all these documents except for this purpose. And so sometimes you can get an exception, but you really do need to talk to the vendor. So my reaction there would be to say to the patron, like, thank you for asking me first. I do need to look at our licensing or contact our licensing librarian, and maybe we need to contact the vendor because this might violate our licensing with our vendor, and we don't want to get in trouble for breach of contract. And so they would have to be patient and wait for you to run that through the right sources. What about a professor wishes to make a copy of an entire textbook to put on e-reserve through the library? What should you do? Well, this has become a really big issue in COVID-19, right? A lot of professors, they really want to make copies of entire books and a lot of times textbooks, right? Because their students can't get to the library, and so they can't, normally they would have a physical book at the library that the students would come and check out, but our library has been closed physically. Unfortunately, that's usually not a thing that we're allowed to do, right? An entire textbook for e-reserve is usually not okay. We can usually put short amounts on e-reserve. In the United States, we're relying on fair use, right, to do that. There are a couple things that I usually recommend instead. One is we look for ebook licenses. So sometimes the book is available in ebook format where you can license the ebook through the library and the students can get to it that way. If it doesn't have very restrictive licensing, like it allows an unlimited amount of students to get to the book and it's not unreasonably expensive, that's a good option. Sometimes it's not a good option. Sometimes the book would be way too expensive through the library, or it would only allow, you know, one student to access it at a time or something like that. So sometimes there's not a great solution. I do recommend faculty start looking at open educational resources or resources that are available online for free. There are online textbooks that are available for free, and those are really great resources. Unfortunately, they're not available in every subject yet, and it's starting to really get better. But I don't think that this is usually an appropriate approach to take, right? To put an entire book. Now, you could reach out to the publisher and tell them what the issue is and ask if they're willing to make an ebook available if they don't already have one, or something of that sort. Or you could license parts of the book if the professor needs to use most of the book, but not the whole book. You might be able to make a course pack or something like that. There are a variety of things you could do, but putting an entire book on eReserve that's in copyright is usually not okay under copyright law. What about this question? A student accesses articles through the library database and wishes to post them on his personal library webpage to share them with his friends. What do you do? Well, I would have a talk with the student. The student probably isn't aware of library licensing, but most articles, when you get to them through the database, do have a copyright notice on the top. And I would explain to the student that the copyright notice means that this work is in copyright and owned likely by the journal publisher. And so it would be a copyright violation to post them on a personal library web page and sharing with friends, right? Because those articles are paid for by the library, they're available to students. And if his friends aren't students of that university, then it would be violating copyright and the terms of the service or the contract with the library. So just to enlighten the student a little bit about how the library engages with the publisher and to let them know that this could have negative impacts on future relationships between the library and the publisher. So this is my final slide. I welcome your questions if you have any, and I'm happy to kind of do my best to answer any questions that came up during my talk. Thanks a lot.
Thank you so much, Dr. Sarah. I think it was very comprehensive presentation, and the way or the approach that you adopt about question and answer, I think shorten the way for many of the attendees to answer their questions. Even that we have many questions still down the road. I try to summarize all of them. And at the same time, I think it's very important to have this ethical way for what we are doing, because I think you mentioned in different slides, in the United States, the librarian is not allowed to, not monitoring, but at least not to give an action, which is, it's a tough action against the librarian. So I think at the same, on the other side, that all the users should be educated with the deep meaning of educating the library users. That means that to make them aware more about the licensee's articles or points, and at the same time to tell them that you have to protect the author, because one day you will be an author. So you will not accept, or you will not think about it's good for you or for your career to let someone just take your efforts and research. So this is just a brief about this, and I would like to thank you about this very controlling of the time, and tried to summarize again what we have from the question, and it's open for anyone need to add another question. Briefly, we have a question here from Ola. She said that, does publishing journal article of researcher in the university or in the university website interfering the copyright or affecting the copyright?
So that's a really great question, and the answer is, as in many of these types of questions, it depends. Sometimes you have under your, well, let me take a step back. It also depends, it depends on many things, but it depends on who is posting it, right? If I wrote something and I published it with a publisher, and it's not an open access journal, it's a closed, subscription paywall journal, then it depends on my author's contract. So I may have the right under my author's contract to publish that journal article. Sometimes they call it like a pre-print version, like not the pretty version that's the final version, but the earlier version that I submitted. Sometimes I can post that on a personal website, or in my institutional repository through the library. But it really depends on the journal. So reading the author's contract is really important there. And that is a really great opportunity to educate authors about negotiating with journals when they publish. So to remind them that they might want to reserve some rights. If they do transfer copyright to the journal, they might want to reserve some rights to share their work in their teaching and at their institution through the institutional repository. So that is the answer if it's the author trying to post it. If it's the library trying to post it, then they're going to need to look at the author's contract with that journal as well, right? Because they're basically kind of working as the agent of the author. And still, that author's contract might allow them to put it on or not. And so even if the author is giving to you, a librarian, saying, hey, put this, I want this out in the world, put it on the institutional repository, it's important to remind them that they might not be able to do that. Right, that they need to look at their author's contract. And again, I think it's a really good opportunity for education to take the time to remind authors to negotiate. I always say to authors, you know, would you go in to buy a car and just say, yes, I'll pay full price, right? You wouldn't. You would negotiate and you would haggle with them and say, well, how about $1,000 off the sticker price and free oil changes for a year or what have you? Well, same thing with journals. You want to ask them for some of your rights. You want to ask them to be able to share the work with your colleagues and with your students and with your institution.
Okay, thank you. There is another question from Mustafa Muhammad, and he said that, as I understood for his point of view, copyright is expired after author life plus 50 years, and in the other countries such as US after 70 years. So is it based on the nationality, or it's about the author or it's about the country of producing the item?
That's a really great question. It actually, copyright law is territorial. And what that means is it depends on where you are. So if I write something and publish it in the United States, then United States law will apply. But if I go to Saudi Arabia for studying and I write and publish something in Saudi Arabia, then Saudi Arabian law is going to apply. Often though, I will tell you, authors nowadays are doing more and more publishing in many locations, right? So they might be publishing something in Saudi Arabia and the United States, or doing translations. And so it gets complicated really fast, but that's where the Berne Convention is really helpful, because it does say that those countries are going to respect each other's laws. So in the United States in particular, it's interesting because we actually give more protection to international authors than we do to our own. So our own authors might lose copyright in an era where formalities used to be required from the 1920s to the 1960s or so. But if you're an international or foreign author, we will say, oh, you didn't understand our law, we're going to still protect it. So we actually give more protection to international authors than we do our own often, which is one of the weird parts of US law, because we don't usually do that. But in copyright law, we do, which is interesting.
Okay. We have Hamoudi here, and he said that, or she said that her PhD is about this topic. We hope that we helped you, Hamoudi, about your thesis with this workshop. And she said that her first question is about how librarian can balance between protection of the property of copyright and open access of the information for the all users.
That is such a great question. I think that open access is not necessarily contradictory to copyright protection. And I guess the reason I think this is because, to me, I do a lot of publishing open access. And to me, it is more control, because when I transfer my copyright to a publisher, I have no control. I give up all control to it. And I say, okay, publisher, now I have to pay you to access my work, right? I mean, my library is paying the publisher to get that work back. But when I publish it open access, I actually retain the copyright, and then I license it myself openly through Creative Commons usually. And in my view, it gives me more control because I can pick the Creative Commons license I want to use. I feel like I can do more with the work, right? I can make derivative works. I don't have to ask the publisher for permission to reuse the work because I still own the copyright. So in my mind, it's not necessarily contradictory. I think it makes me feel like I have a little more control as an author.
Okay, good. Ms. Thana Hamoudi, I have another question. It's related to, okay, it's a very long question, but the summary of it, it's talking about during this COVID-19, what she can do if she is forced by the top management just to digitize a book or something like that, and then make it available to the users. I think it's administrative answer, need administrative answer about this. Let's formulate it in another way. How you can advise her if she or any other librarian forced to take an action, it's against the copyright law. What is the best way?
Yeah, so I think that's a good question. It puts you in a very hard position if you're asked to do something and you feel like it's against the law. I think it's a good idea to maybe have access to your copyright law and to provide the copyright law to the administrator and point out that you don't feel comfortable with it. That is obviously one way. I don't know if you have access to the general counsel at your university. I work very closely with the general counsel at my university, and if I were ever asked to do something I felt was illegal, then I would contact the general counsel and let them know, because that is potentially creating liability. But there are other ways to minimize risk. So a lot of universities, including mine in the United States, are expanding on fair use right now during COVID-19 and making more and more digital copies available under fair use just for researchers. But what we're doing to keep that keep the liability down is we are putting them behind obviously paywalls, where we're putting them behind protected walls so not anybody can see them, and we're lending them with that we're not allowing downloading of the materials. So when the patron sees the material, they can only look at it. They can't download it and further share it. And of course, keeping copyright notices on those shared materials and sharing them only for a limited period of time. So what we've been doing is what's called controlled digital lending. You've probably heard about it. It's a very big thing going on right now in the United States. And what it is allowing our users to view a digital version of a work that we have in our collection. So we have a physical book, and saying to them, you can look at this digital version of the book for 1 hour, and you can't download it or do anything else. It's because you can't physically come into the library right now. So that's something we've been doing. We're not necessarily doing that with textbooks and things, but with research books. Because our researchers cannot get into the library. With textbooks, the students can order them online and still pay for them. So we don't want to usurp that market, right? Because that gets problematic. But for the researchers, we are using, it's called the HathiTrust Emergency Library. You can look it up if you want to see the way it's operating. That's how we are doing it at my institution. We're using the HathiTrust Emergency Lending Library. And if I would say, if you can model it after that type of lending under a very restricted way, you're going to be limiting some of that liability. Sometimes there's no such thing as no liability, right? But we want to limit the liability.
Good. I try to, if there is question, just merge it together to do. but there is one, it's not question, but retrieving again the concept of the first sale. Can you brief it a little bit and link it to how this could affect library service?
Yeah, so the first sale is a very important concept in the United States. And I'll give you an example using a real case, if that helps. There was a case about a student, his name was Supap Kirksong, and he was from Thailand. And he asked, he went to Princeton University, I think, in the United States. It was some Ivy League, it might have been Cornell or Princeton, and he asked his family in Thailand to buy the textbooks in Thailand because they were in English and they were cheaper there because the market was cheaper there. And they shipped them to him in the United States, and then he sold them online through eBay, and to his fellow students in the United States, and he made $1.2 million. Wow. He was then sued, of course, by the publisher, Wiley, and Wiley said, hey, we want some of that money, right? You sold our textbooks and that's not fair. And the Supreme Court of the United States said, too bad, Wiley. He was allowed to do it. You sold those books in Thailand and you're done. You got your money. And so, of course, what happened was that publishers got smarter, right? And they started selling the books in Thailand in a different language so that they couldn't just sell them in the US and things like that. But the point is, that's the right of first sale at its finest. It's saying, if you sell the book, publisher, then your interest is done in that physical book. It doesn't allow us to make copies of the book, but it allows us to take that physical book and sell it, or lend it, or do whatever we need to do with that.
Okay. Thank you, Sarah. And for sure, our co-host, Dr. Ali and Mohandas Muhammad, are allowed just to join us with their reflection on what we have just said, or what Sarah already mentioned in this. So please, Dr. Ali, and then we will continue our question with our attendees. Please, Dr. Ali.
Yes, thank you very much, Dr. Abdullah. And thank you, Dr. Sarah, for this informative presentation. Really, it was very good. We have learned a lot of things regarding the copyright, and you highlighted many important issues regarding the copyright. I have two main concerns, especially during this pandemic. We were working before maybe the coronavirus on campuses, and we were attending classes based on the face-to-face settings. But after this situation, we found ourselves that we have to shift to the online classes. And we use the virtual classrooms and different resources. My main concern is regarding what is called the learning management system. We can see that many of our instructors or maybe teachers in other institutions are using this LMS to share different types of resources with their students. What we found that some of the teachers are sharing like ebooks, or sharing some of the resources, articles, or maybe researchers. They research, sorry, from the internet. They can get them from the internet. Then they share. Now, as an LMS administrator, or maybe as an agency responsible for this content or managing the content, what should we do if we found some of these types of resources? Shall we delete them directly, or is there any legal or illegal activities that could be among the teachers, and maybe they will have it like a habit that we are now inside or maybe internal this institution and nobody can see that, so we can't do it. This is my first concern. If you allow me to finish all the points, and then I will let you, inshallah, answer all of them. The other concern is related to the ebooks. One of the responsibility that have been assigned to us in our e-learning agency from the Royal Commission, that we have to create a website that could be an electronic resource for our teachers and also students. We were collecting different types of resources, and I mean here ebooks from like Harvard University, from Stanford. They are distributing this, or they have them in their websites. So if we have them now, or we copy, you know, these URLs from their main websites and put them in our website, is this a kind of a copyright issue or problem? Because it's open there and we can classify it as open source, but we are not sure about maybe the process that we have followed. Thank you very much, Dr. Sarah.
Those are both really good questions. For the first one, what we do, at least at the University of Illinois, is that we consider that the faculty are responsible for their own learning management systems. So I know it varies. So this is maybe not the same at other institutions. And I have colleagues at private institutions that do go and look through the LMS system. I do not. So it varies and it depends on what your policy is. Here at Illinois, what we view the LMS as the purview of the professor, and we don't have an e-reserve system at the library level anymore. We used to, but we stopped because it wasn't widely used. More and more professors were using their learning management system. So what we do is we try to educate. I meet with professors often. They email me with questions if they have concerns about what they're allowed to put on their LMS. I have a lot of what you call library guides that explain copyright law so that they can make informed decisions about what to put on their LMS. But I do believe, and I understand your concern, that a lot of faculty don't understand copyright law and might be doing things that maybe are not justified. So I think that depends on your level of comfort, I guess, as an institution, because at University of Illinois is such a big institution. There's no way we could look at every single thing posted on, you know, a learning management system. And so we put that in the purview of the faculty members. Now, if we were smaller, we might have the ability to look through them all. Also, we of course do get takedown notices for things that are put on public displaying websites from the university. And in that case, our legal counsel will answer that. Because that is considered purview of the university itself. And so we kind of draw a line between what is considered potential liability for the university versus potential liability for faculty members. The other thing I would say about that is I have some best practices that I recommend. For instance, if faculty members are trying to share a journal article with their students, chances are, at least at our university, that they're trying to share a journal article that we have in the library. So in that instance, I recommend that faculty actually link the students into the library to the direct object identifier, or the DOI, so that the student would have to log into the library to see the item. And that just verifies that the student is not just downloading and, you know, and it puts an extra step. So the student would have to actually like download and then send the item if they were trying to make a copy of it. It also ensures that the student is going to understand that, oh, this is a library item. It also ensures that the copyright notice will be on the item, right? Because we don't know what the faculty member has done with that item, if they've removed pages or something like that. And finally, it also helps for library statistics, because we see how many students have actually logged into each thing, and we would know this journal is being heavily used as opposed to just the faculty member downloading it. So that's one piece of advice that I use for faculty members. But certainly that is an issue, and there's no simple solution, unfortunately, but I think it depends on what your institution is looking at in terms of ability to look at all of those LMS systems. And certainly some of campuses in the United States do look through them. I think the majority do not, because there just are too many, and we put it in the purview of the faculty and tell them, like, this is on you. You know, if you've done this, like, and the publisher comes after you, they're going to come after you as an individual because you made that decision, not the university. The other question that you had was about linking, and I think that's a really great question. So if there are things on Harvard's, let's say Harvard's website that don't have paywalls, right, that are on the internet, that may or may not have copyright or not, right, because things are still copyrighted. Some of them might be OER or open access with licensing, some may not. Linking is always a great option. In the United States, we don't consider linking to be copying at all, because basically what you're doing is you're sending your students to a website. That's totally fine, because that way you're not downloading and uploading anything. It's similar to my argument for LMSs and linking students into the library, right? Is that you're sending someone to this website. So I think that's a really good option. In the United States in general, we don't consider linking to be a problem. And of course, the risk with linking, there's always a risk, is that if there's no DOI or direct object identifier, the link may go down, right? Or if Harvard changes their policy or they take down whatever item you've been linking to. That's the only risk there, but it's a pretty small risk. And I think I do recommend linking to things if that's available to you.
Okay, Dr. Ali, if you have any other comments on this answer, you're welcome.
Really, it's a great explanation about the two maybe concerns. Thank you very much, Dr. Sarah, and thank you very much, Dr. Abdullah. And really, we enjoyed this webinar, and hopefully that we can have more, and we can get more maybe webinars regarding different maybe issues. Thank you very much.
We're still, by the way, having time, because I think we have many other questions. So I think we still have this one for sure. Once, Mohammed, if you need just to have any question, you are welcome to join us as well.
Thank you, Dr. Sarah, for this wonderful presentation. And thank you, Dr. Abdullah. Thank you, Mr. Saeed. It's a very good seminar.
Okay, let's go back to question, because we have many questions. It's exceeding 4 pages I have, so I try to summarize, and at the same time need to give the notes on the certificates and also the presentation. Usually in the academy, we share this certificate based on the cooperation with the Royal Commission. So it will be sent to those who already attend the webinar. This is the first thing. The second thing, the presentation, we always put it on the website of the Academy, and for sure we will share it with the Royal Commission for this one. Let's back to the question. We have here question related to the translation. It's come from Muhammad, and there is another one, Mustafa. They're asking about the same thing. Why I have to get a permission from the author if I translate the book or his manuscripts in other language? I know the answer for this, but I let Sarah just comment on this one.
So that's a good question. And a lot of folks do think that translations are something that they should be able to do without permission. But under copyright law, one of the rights exclusive to the author is the right to create derivative works, and a translation is considered a derivative work. And if you think about it, it's basically trying to repeat or copy the entire work in a different language. And copyright in the title says copy, right? And so that's the main thing we're trying to protect against, is making copies. And so that is a right that is exclusive to the author, or if they've published the work, you would want to ask the publisher for permission. And certainly you might be able to get permission. I would hope that you could get what's called gratis or free permission, especially if you're doing it for a library or for people who are trying to do research. But the reason that that's protected is that the publisher might want to make a translation themselves and then sell it. Right? And so that's one of the things that they have in their kind of purview, right? I've written a book for the ACRL, and if the ACRL wants to make more money off of it, they might choose to make a translation into a different language. And if they do, they'll sell it. And so that's why you do need to ask for permission before making a translation.
Yeah, and also I think Sarah, transferring the ideas, it is very important that the main author make sure that it's transferred honestly and also in the culture that will adopt it in his idea. So thank you for this one. There is another question from Fatima. She said that, okay, if someone buy a novel and transform the content into script scene for a movie, does he need, or this is affect the copyright, or this is illegal?
That's a really good question. And the answer again is it depends. Usually, yes. So usually you'll see that books often are modified into screenplays or for movies. And the author does get quite a bit of money for that because that's considered a derivative work, right? And so that's the right of the author. And then what will happen, even if they're not the screenplay writer, they'll have to get permission and pay a licensing fee to the author to make that screenplay. However, you know, it depends on what you're doing. If you're using just a very, very small amount, that might be, at least in the US, considered a fair use. The other exception is when if you're making like a critical commentary or a parody, which is like making fun of something, that's another part in the US where you wouldn't necessarily need permission, but usually you would. Yeah, usually you would.
Yeah. Okay, another question from Professor Amal Wajih, and she thank you very much about this fruitful session. And she asked about that some vendors provide tests and exams or exercise with the ebooks as a supplement. I think she's mentioning that, or when like Pearson in mathematics. She asked about if the library takes a decision to publish this exercise standalone on her e-resources portal. This also supposed to be against the copyright?
Yeah, so that would probably be a problem because usually what happens is with Pearson in particular, they have a homework code. Students have to purchase actually in addition to purchasing the book, they have to purchase like the homework or test bank. And this is the thing that really bothers me because I know students don't have a lot of money and then they have not only to purchase the book, but they have to purchase these other things, right? And I understand that people feel bad for the student and they want to copy the thing, but without permission, it would be a problem. Yeah. So one of the things that I really recommend, and this is why I recommend open educational resources, is there may be a book through OpenStax is a really big resource that has not only the book, but also test banks and things that people can use that have no charge. I've had professors who have been using Pearson for years and then realize that they can make their own test banks. And so they might use the book, but they stop using the test bank because they don't like the students having to buy an extra thing. So, you know, one option is to have the professor make their own test banks. And an ingenious way to do this, if you have some creative faculty, is to actually assign it as homework to the students and have each student write 10 to 20 questions with answers for a test bank, and that's part of their grade. And then guess what? You have a test bank for the next time, and it's free, and the students made it. So I know a lot of faculty are doing it that way now.
That's good. Okay, this question is related to how to handle the copyright for the new technologies like the Internet of Things, hologram, and also the content of virtual world like Second Life. Do you think this is a special treatment for this type of content?
Oh, are you talking about virtual reality content?
Yeah, and Second Life and holograms and this
Hologram.
special technology that already included content, but at the same time, it's not that normal type of content that we deal with it. How the library can handle such programs or content?
Well, I think it's all going to be about licensing, right? So it's just a lot of the things that we're handling right now are electronic, and this is just another version of electronic resources. And so it's going to be, and we actually at our library only have one librarian who deals with electronic resources, and we're realizing this is not sustainable. So we're hiring at least another one, and then we're going to come up with an ad hoc team of people to look at licensing questions, and I'll probably be one of the people on that team because it's such a big issue, right? Because we do have all these new technologies and new terms that we need to understand, and all of that. But it's going to become, what happens with this stuff is it is copyrightable, but then you have contracts. So, and the contracts trump all of your rights under copyright. And what we try to do in the United States, at least, is to get into our licensing terms to say something like, we reserve all of our rights that we otherwise have under copyright law, right? Because we want to reserve our right to fair use, our right to library lending, interlibrary loan, and on e-books and things like that, it's almost impossible to reserve those things because the vendors don't want us to. In fact, we don't really even own the e-books. We rent them, right? So the library licensing is a whole nother topic, and it's so complicated, and it's getting more complicated. And you've highlighted one of the areas where it's just going to get more and more complicated. So I would say, you know, read your contracts very carefully, advocate for library exceptions where you can, and you're going to have to start keeping like spreadsheets of the different licenses because they're all different and it gets complicated.
Yeah, we're still having what we call a flow of questions, but I will take two more, and we welcome for sure the rest of the questions just to answer it over the emails. And I think Dr. Sarah is agree with me about this. So one question related to how about just making copy of the book and to be used within the organization, for example, if it's a consulting firm. So is it okay or not?
So we actually had a case like that in the United States where a consulting firm was making copies of things just for their own internal use, and the court said that was a violation. So especially if you're not considered a library, so they were doing this for just internal use, and again, it's violating copyright, because if you needed more copies of a book, for instance, then you should either lend that book around the organization or you should buy more copies of that book, right? And what they were doing also was, you know, they were not subscribing to a journal, but instead they were making copies of a journal that they got from somewhere else. No, can't do it. So people are going to have to make decisions about, you know, where to put their money in terms of licensing and which journals they really need to purchase, unfortunately.
Okay. Thank you. Last question is about just taking part of manuscripts or figure from a book and use it with citation. Is this okay? I think this is a very obvious thing, but I let you answer, Sarah, just and wrapping up the session.
Well, it sounds like you're trying to quote something.
Yeah.
And if you are doing quotations, that's usually not a copyright violation as long as you are citing and things like that. So different people view figures differently, right? Because sometimes those are copyrightable depending on some factors, right? So it depends on how creative the figure is and whether you can just get the facts out of it, right? Because facts are not copyrightable. And so sometimes you can just take the figure because it's just facts, and other times it's very creative, so you might need permission. And so there are some variables about the figure part, but for quotations, that is perfectly okay. You can definitely use quotations, and even I've written book reviews and I did not ask for permission to critique the book, right, and quote from the book in that book review. That is perfectly acceptable.
Yes. Thank you, Sarah, so much. It was a really, really very knowledgeable session, and I think this is couldn't be done without this cooperation from the Royal Commission, Jubail and Yamba. Would like to thank again Dr. Ali Bar and Muhandis Engineering Muhammad. Please, if you need just to comment and wrapping up, Sarah, before we left, and Dr. Muhammad, for sure, we're happy to listen to you. Just to wrapping up this session was a promising for all attendees and those couldn't attend with us, but shared their comments over the live Facebook. We promised them to another series of co-webinars. Dr. Ali, please, if you need comment.
Thank you very much, Dr. Abdullah. And thank you very much, Dr. Sarah. It was a wonderful webinar. We got a lot of new maybe information to us, and we have learned a lot. Hopefully that we can get more webinars talking about different issues. Maybe the session was not maybe enough to answer all the questions, and also to maybe answer all our concerns. We have more. We want in the future maybe to talk about maybe the virtual libraries, and also the future of the libraries in the new digital age. One of the participants mentioned one of the things, the virtual reality. And in fact, we have a technical institute and we are developing new electronic courses. So we are using now the old traditional books and we move them to this new environment. But maybe we can talk about maybe this in future, maybe in next webinars, and hopefully that we can get more. Thank you very much, and thanks to all the participants for attending this webinar.
Thank you, Dr. Ali. Thank you, Muhammad Muhammad, Engineer Muhammad. Thank you, Professor Sarah, and thank you for all the attendees, and keep following up our events in Nasij Academy, and we really glad to have this all attendees with us, and have a safe night and calm life. Okay. Assalamu alaikum. Thank you, sir. Bye-bye.
Thank you very much. Thank you, Dr. Saad.
شكرا دكتور علي. شكرا مهندس محمد.
Thank you. Assalamu alaikum.